Thank you for joining Jennifer Schaus and Associates in our 2019 Webinar Wednesday series. We are coming to you live from downtown Washington, D.C. Our webinars are every Wednesday, and you can find the upcoming schedule on our website. Past webinars and all recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email him directly to the contact information you'll see on the last slide. Just a little bit about us. We are a Washington, D.C. based firm, and we provide services for federal contractors. This ranges from market analysis reports to proposal writing and also post-award compliance. More information is on our website, so please visit us there. Today, our speaker is Timothy Byrne, and he's going to be covering teaming versus joint ventures versus mentor protege. Tim, thank you for joining us, and I'm going to go ahead and hand it over to you.
Well, thank you so much for having me, Mallory. I'm very excited to be here. Good afternoon, everybody. My name is Tim Fern, and I'm a partner at the law firm of Ward & Berry in Washington, D.C. I focus my practice on federal government contracting and have over 16 years of experience, both as a government attorney with the Army and in private practice. Today, we're going to be talking about the different types of partnerships that government contractors can form to leverage their capabilities for more and better contracting opportunities. Like Mallory said, we don't have a question and answer session, but I'm certainly happy to take any questions, and my contact information will be on the last slide. Next slide, please. All right, before we get started, I think it's important for everybody to have a basic understanding of the different types of partnerships that can exist. First, there's teaming, and teaming is a type of prime subcontractor relationship that is implemented through a teaming agreement or subcontract agreement between two or more parties. This is the type of relationship that you typically will see in federal government contracting, where you have one prime contractor and one or more subcontractors. The next type of relationship is a joint venture. A joint venture is a business agreement in which the parties agree to develop for a finite time a new entity and new assets by contributing equity. The parties control the enterprise, and consequently they share the revenues, the expenses, and all of the assets. And then finally we have the mentor-protege relationship. And this relationship follows the guidelines that are contained in specific programs that allow companies to form a specific type of relationship for the purpose of the business development of one company. Next slide, please. Let's discuss some fundamental concepts that will inform your decision as to what type of partnership you should form. First, what is a small business? The Small Business Administration sets numerical definitions, or what we know as size standards, for every nonprofit small business in the United States. These size standards are based on the business's number of employees and average annual receipts, and they vary from industry to industry. If you're involved in federal government contracting, you're going to know about the NAICS code, and the NAICS code is essentially going to determine the size standards for your business. Now, one of the most common small business programs is the 8A Business Development Program. The 8A program is a business assistance program for small disadvantaged businesses. The 8A program offers a broad scope of assistance to firms that are owned and controlled at least 51% by socially and economically disadvantaged individuals. To be eligible to participate in the 8A program, a business owner must have a net worth of $250,000 or less, have personal income of $250,000 or less, and the fair market value of all assets of the owner must be $4 million or less. And that's to be eligible to participate. Once you've gotten into the program, to maintain your eligibility, a business owner must have a net worth of $750,000 or less, personal income of $350,000 annually or less, and the fair market value of all assets must be $6 million or less. So in addition to the 8A Business Development Program, which again deals with socially and economically disadvantaged individuals, there are also some other small business programs that are out there. There's the HUB Zone, or Historically Underutilized Business Zone Program, which is really based on residency requirements, where the government's trying to get business into areas that are economically depressed. There are veteran-owned small businesses and service-disabled veteran-owned small business programs that are programs for veterans that are run by the Veterans Administration and the Small Business Administration, respectively. And then there are women-owned small businesses and economically disadvantaged women-owned small businesses. And these generally deal with industries where women have historically been underrepresented, based again on their NAICS code. So let's look at what is a set-aside contract. To help provide a level playing field for small businesses, the government limits competition for certain contracts to those small businesses. These contracts are called small business set-asides, and they're used by the government to help small businesses compete for and win federal contracts. The current goal of the Small Business Administration is to set aside 23% of all federal contracts for small businesses, and the individual goals within the different programs that we just discussed will vary. And again, these goals are aspirational, and in most cases, they're met by the Small Business Administration, and in some cases, they're not. But there's currently a lot of movement going on with regards to small businesses and the set-aside programs in Congress and some of the areas. So those goals may change. So what is affiliation and why is it important to our discussion? Generally, affiliation exists when one business controls or has the power to control another, or when a third party controls or has the power to control both businesses. Control can arise through ownership, management, or other relationships or interactions between the parties. Affiliation is important to us because the Small Business Administration determines whether an entity qualifies as a small business concern by counting the amount of money it receives, its employees, and it also measures the receipts and employees of anybody who's affiliated. So affiliation is a key concept that we need to keep in mind when we're talking about teaming and when we're talking about joint ventures. So why would a business want to form a partnership? There are distinct advantages to forming some types of partnerships. There are also certain disadvantages to forming partnerships, and we're going to cover these a little bit later in the webinar. And finally, the type of partnership that you choose to form will define both the benefits and the risks to your business. Next slide, please. One of the biggest distinctions between the different type of partnership is which company actually serves as the prime contractor. When we're dealing with teaming or subcontracting, what you will typically see is the small business is going to serve as the prime contractor in order to be eligible for a specific procurement that's set aside for small businesses. When we're dealing with joint venturing, this is when two companies form a joint venture. The joint venture itself is the prime contractor for the contract. The joint venture can then subcontract to a JV partner if it wishes, and this is one of the advantages that large businesses enjoy if they enter into a joint venture with a small business. Typically, a large business will only be eligible to perform 49% of the work. If it's in a joint venture, it can then subcontract to itself and perform up to 60% of the work. And then lastly, we have the mentor protege. These relationships are not formed for a specific procurement. They are, however, usually used in the joint venture context. Next slide, please. All right, some common affiliation issues in joint ventures. And again, affiliation is important to us because it's how the SBA is going to determine whether or not we qualify as small. So the general rule with joint ventures is that members of a joint venture are presumed to be affiliated with each other for purposes of any contract for which the joint venture competes. In other words, when parties form a joint venture, the members are per se affiliated for the purposes of whatever procurement just by the virtue of the joint venture relationship itself. Next slide. There are two exceptions to the general rule. First, if each joint venture partner individually meets the applicable small business size standards, regardless of the combined size of the joint venture partners, they're considered small. So if both businesses are small, they form a joint venture, they stay small. The second exception to the general rule is if the member partners of the joint venture are part of an approved mentor-protege program. And there are two different mentor-protege programs. The first is the 8A mentor-protege program, and then the second is the All Small Business mentor-protege program, which was recently formed in 2016. Next slide, please. To form a partnership, what needs to be done and when? If we're teaming or subcontracting, which again you would typically see in most government contracts, the team needs to be formed prior to bidding. The teaming agreement is submitted with the proposal in the bid. The concept of teaming often causes some confusion in the government contracting community of practice, and it's important to note that teaming occurs before a contract is awarded. So this is where two or more parties will enter into a teaming agreement for the purpose of preparing and submitting a proposal. A teaming agreement is not a subcontract. If the government accepts the proposal that a team submitted, the contractors will still need to prepare and sign a subcontract agreement. And you see a lot of litigation around this. Folks will enter into a teaming agreement. The prime contractor will be awarded the contract, and they never enter into any kind of subcontract agreement that defines the rights of both the prime and the subcontract. So just teaming agreement is not a subcontract agreement, and we need to make sure that we do both of those. A joint venture, like we talked about, is its own separate legal entity. The joint venture is going to be formed prior to bidding, and because it's its own separate legal entity, it needs to be registered in SAM and VetBiz verified before bidding. Also, if you're going to use the mentor-protege relationship and then form a joint venture, the mentor-protege relationship needs to be formed prior to entering into the joint venture agreement. And we're going to talk a little bit more about that here in a few minutes. Next slide, please. So let's talk about leveraging capabilities. How does the government evaluate past performance? For teaming arrangements and subcontracting arrangements, it varies slightly than it does for joint ventures. So when we're dealing with a teaming arrangement, if the procurement is a negotiated procurement being conducted under FAR Part 15, what the FAR says is that the contracting officer must consider significant subcontractors' past performance. If the procurement is being conducted under FAR Part 8, which is required sources of supplies and services, the agency has the discretion to disregard such references. And this is how it's different for joint ventures. What it says is when evaluating the past performance and experience of an entity, submitting an offer for a contract set aside or reserved for small businesses as a joint venture, a procuring activity must consider work done individually by each partner to the joint venture, as well as any work done by the joint venture previously. So this is a huge advantage to being in a joint venture relationship, is the small business gets to use the past performance experience of the large business, and the government has to consider it. Next slide, please. When we're dealing with teaming and subcontracting, there are three things that we really want to keep in mind. And you should absolutely consider all three of these things before deciding to even team. The first is enforceability. There's been a lot of case laws come out recently. Two of the big cases are Cyberlock and Trianco, T-R-I-A-N-C-O. And they really talk about enforceability. And what those cases essentially say is for a teaming agreement to be enforceable, it's got to be more than a mere agreement to agree. So government contractors cannot rely on generic teaming agreements promising work under a future contract. And when we prepare teaming agreements, specificity is key. Language like, if awarded a contract, the prime contractor will award a subcontract to the subcontractor. Not may negotiate. We want very solid words. We will award a subcontract. This is how this is going to happen. The best practice when dealing with enforceability is to submit a draft subcontract with the teaming agreement and specify how and when it will go into effect. And again, there's a lot of litigation on this, and it really depends. The outcome of the litigation is really going to depend on the state where you form the teaming agreement. Virginia has very different laws than Maryland, and both of them have very different rules than the district. When we deal with exclusivity, this is always a tricky area as well. An exclusivity clause is a clause that prohibits one or both parties from entering into other teaming agreements. And generally, this is a really good idea. As a small business, these are especially important if you plan on teaming with a large business, because it prevents the teaming partner from entering into teaming agreements with other small businesses that are competing for the same small set-aside contract. What the large businesses typically try to do is they just want to get into the game, so they'll enter into teaming agreements with as many folks as they can. So you always want to consider having an exclusivity clause in any kind of teaming agreement that you do. You need to be careful though, because there is some case law with regards to exclusivity agreements where you start getting into antitrust issues if you're exclusive with a contractor that's the only contractor that can perform that type of work. And then lastly, when you're dealing with teaming or subcontracting, you want to talk about expectations. You want to consider, managing expectations and setting expectations is going to be the key to a successful partnership. Here are some of the essential provisions in a teaming agreement. You want to talk about the term and termination. You want to talk about protest responsibilities and rights, the roles and responsibilities of the parties, who's going to communicate with the government client. If a subcontract's awarded, you certainly want to talk about flow down provisions, the dispute and resolution process, and in both cases, you want to talk about the protection of your proprietary information, any non-disclosure agreements. We want to talk about solicitation of current employees, and then lastly, and probably most importantly, you want to talk about the governing law. Next slide, please. So what can go wrong? How do we destroy our small size status? We could nullify our small business program eligibility, or there are certainly other areas of non-compliance. And so the most common pitfalls that you'll see with teaming agreements or subcontracts are affiliation, and we've kind of talked about that. We have issues with regards to unconditional control, and then we have issues with regards to the work percentage requirements. So you're going to want to make sure to draft your teaming agreement to specifically address and overcome these areas by clearly defining who's going to have control of the relationship, what are the work percentage requirements, and how are those going to be maintained. Next slide, please. Now that we understand teaming, let's focus on joint ventures. Who can be in a joint venture? Well, we can have two small businesses, and that's certainly a good way to go if you have capabilities that assist each other and help you get a contract, and you would certainly maintain your small business eligibility. But what you typically see is a large business and a small business. And an approved mentor-protege relationship is a prerequisite if the joint venture wants to be considered small and compete for small business set-aside contracts. Next slide, please. There are two different mentor-protege programs. The first is the 8A mentor-protege program, and this is an alliance between an 8A program participant who's the protege and a large business who's the mentor, and the large business is going to be defined again by the NAICS code. The protege has identified needs for business development, and essentially the mentor has the capacity to address those needs. The mentor-protege relationship, again, must be approved by the SBA before a joint venture is created and before the joint venture submits a proposal. And it's important to note that under the 8A program, a mentor can have no more than 3 proteges at one time to try to limit how they're into it. The All Small Business Program was established in 2016, and essentially it was established to extend the SBA-approved mentor-protege relationships to every small business, and those are those different categories that we talked about earlier. It's designed to enhance the capabilities of a protege firm by requiring approved mentors to provide business development assistance in various forms to the protege firms to improve the protege firm's ability to successfully compete for federal contracts. To be eligible to be a mentor, you have to be a for-profit company. You have to demonstrate that you can fulfill your mentor-protege obligations, and generally a mentor will have no more than 1 protege at a time. To be eligible to be a protege, you have to qualify as a small business. A protege can have up to 2 mentors in its lifetime in any program, and a protege firm can generally only have 1 mentor at a time. There are some instances where the SBA may approve a second mentor for a particular protege firm where the second relationship will not compete or otherwise conflict with the assistance that the first mentor-protege provides. And really when this occurs is if the protege is looking to gain experience in an unrelated NAICS code or seeking to acquire specific expertise that the mentor can't provide. Next slide, please. All right, the mentor-protege requirements. So there's a written agreement is a requirement, and there's a template that can be found on the SBA website at www.sba.gov. The written agreement is going to contain a number of specific provisions that deal with performance of work, reporting, compliance, and inspection of records. A violation of the written agreement can be the basis for suspension or debarment. There's also going to be a joint venture agreement that you're going to have to enter into at some point in time, and it's really that's going to state the purpose of the joint venture, designate the managing venturer, and state the work split requirements. The application process is pretty straightforward, and it contains a lot of the same information that's in the written agreement. The SBA is also going to evaluate the mentor-protege relationship at least annually, and there are going to be certain annual reporting requirements and follow-up communication with both the mentor and the protege to see if the protege is actually benefiting from the mentor's guidance. Next slide, please. So here are some benefits of the mentor-protege programs. A mentor and a protege can form a joint venture as a small business for any government prime contract, provided the protege qualifies as a small business. And the larges love this because they get in the game. There's no determination of affiliation or control between a mentor and a protege based solely on the agreement or any assistance provided pursuant to the agreement. And recall, this is very different than if we have a joint venture without the mentor-protege relationship in place. And then finally, a protege firm can agree to sell an equity interest of up to 40% to the mentor firm in order to raise capital. And this is a huge benefit to the protege firms as they try to get established and grow and graduate from the small business programs. Next slide, please. So the specific requirements for each program can be found in the Federal Code of Regulations. I've laid those out there for you on the slides. What I would like to note is number 5 there. For both the Veteran-Owned Small Business Program and the Service-Disabled Veteran-Owned Small Business Program, those entities also have to be separately registered in VetBiz. Next slide, please. All right, again, my name is Tim Fern. I'm from the law firm of Ward & Berry in Washington, D.C. Thank you so much for joining us today. I hope that you have a better understanding about the different types of partnerships that government contractors can form to leverage their capabilities for more contracting opportunities. Again, I'm happy to answer any questions, and I can be reached at tim@wardberry.com.
Thank you so much, Tim, for sharing your knowledge and insight today. The recording will be posted in about 48 hours, and if you have any other questions, please email Tim. Thank you, everybody.